If I could have your attention, please. We're going to get started. I appreciate everybody coming today, and it seems like there's quite a bit of interest in the accountability courts, and I appreciate your interest in your getting out this early in the morning. I know it's not a good time of the day to be traveling in traffic. We're going to do something perhaps a little bit different than what you're used to if you've been attending any hearings in the House or the Senate, and it's going to, I think, require all of us to be a little bit more cognizant of our fellow persons, because I'm going to try to conduct this as a roundtable discussion, and we got a lot of folks, and so don't want anybody hogging the mics, but I do want everybody to have their say-so. And the way we're going to do it is rather than having individual witnesses come up to the podium, say their piece, and then sit down, because we're dealing with so many different issues that it very well may be that somebody raises something or a question is asked during the course of somebody else's testimony, and you've already testified, and you say, you know, gosh, I wish I could respond to that, or I wish I could put my 2 cents worth, but you know that may not be possible. So what I'm going to do is the folks who we have asked to speak, I'm going to just get everybody, and I think we got more than can sit at these tables, so I'm going to put the rest of you right here so everybody's got a mic, and we're going to go issue by issue and let us just discuss it, and I'm going to turn on the mics of everybody on the committee so that I don't have to recognize anybody, and we're just going to discuss these issues because there's a lot of interest in this. I want to make sure that we get it right the first time, and so I want to hear from everybody. And so anyway, I've got a list of folks that we thought might show up today, and I want to call names and see who's here, and then if there's somebody that's not on the list that feels like that they want to participate and have something to contribute, then I'm going to see if there's anybody else here that would like to speak. First of all, we've got Ryan Teague. Is Ryan here? Yes. Yeah. All right, we've got Ryan Teague. We've got Judge Jeff Bagley. We've got Judge Jack Partain and Marla Moore from AOC. John Zoller. Yeah. I mean, fill up those chairs and then come on up here. Is John Zoller here? Okay, John. John Pridgeon, Judge John Pridgeon. Judge Steve Goss. Y'all just have a seat. Judge Kathleen Goslin. Judge Bob Castellani. Well, you noticed I hesitated first. I had to sound out the syllables. Judge D. Downs. We had a tentative Judge Brenda Weaver. Okay. We also had a tentative Andy Cumming. Okay. Frank Berry. Is Frank Berry here? Stan Cooper. All right, that's everybody I had on my list. Is there anybody else here that wants to speak on the issue, or you just want to listen? Good. Yes, sir. Okay, come in. Kent Lawrence, and you're from where? Okay. All right, I've got mic 1, mic 2, mic 3, and mic 4, and 8. Are you on 8? Yeah. 8, 9, 10, 11 and 12. I've got my witness mics. And Alan, where are you?
Number 15.
And 16, sir. 17 and 18 and 21. Yeah. All right. So what we're going to do, I mean, as all of you know, there's $10 million in the budget for accountability courts, and there's no direction on how that money is to be spent. And I know that accountability courts, it's one of those things, you know it when you see it, but I don't know that it's been ultimately defined. And I know that there are stages that you go through if you're setting up an accountability court. And I have heard from several judges that it is not practical to put $10 million in accountability courts and think you're going to get 10 courts that are going to be up and running and functioning. And there are so many components of it. There's so much support services. There's a grant stage for planning, and then there's a grant stage for implementation and operation. We've got courts in existence that may need to expand. As one judge told me, that there's some that are running on fumes now, and with a little bit extra money that they could reach some extra people. So really want to hear from y'all about a lot of these different components so that we can make sure that we get the biggest bang for our buck as far as the $10 million, that we don't waste it, that we put it where it needs to be, that we try to get some results. And, you know, quite frankly, later on we may even discuss, because the Criminal Justice Reform Council had several recommendations. Accountability courts were one of the recommendations, but some of the other recommendations were to give judges alternatives to either prison or straight probation, like probation detention facilities and day reporting centers and those kinds of things. And it very well may be that we need to start off and use some of this money for planning grants and some of this money for these other alternatives, because not everybody either needs to be sent to an accountability court or I mean, there are other needs that we've got out there, and we're going to address some of those. So what I'm going to do, one thing we are not going to discuss today, because that is a topic for a different day and a different issue. We're talking strictly accountability courts. As you know, that currently accountability courts are being funded through the AOC. The governor's recommendation is to put this $10 million in CJCC, and we are not going to talk about who's going to be the funding agency today. That will be a day for another topic for a different day. But strictly we're talking about accountability courts and how to address and design this money so that we get the best bang for our buck. And so we're not going to talk about that. The first topic that I want y'all to address and to discuss with the committee, and like I say, this is a roundtable discussion, and so just, you know, if you got something to say, you know, you don't have to be recognized. I just want you to say it as soon as whoever speaking is finished. But I also don't want anybody to monopolize, because we do have quite a few folks that do want to speak. So committee members, panelists, everybody just feel free to have a discussion. The first topic is the components, because if I set up an accountability court with a judge that's my accountability judge, but I don't have the mental health or the additional drug testing or the additional probation officers or whatever it is, it isn't going to work. So the first thing I want to talk about is the infrastructure and the guys that are the boots on the ground, which are you guys. Tell us about what we need, how y'all are doing that now, whether you're contracting it, whether you're staffing it with court personnel, you know, how y'all are doing that, and I just want to hear from y'all on that. So the first issue is, what are the components of accountability courts and how should they be funded? don't jump in.
I guess I can go ahead and tackle that. I'm Jeff Bagley. I'm a Superior Court Judge in Bell-Forsyth Circuit, and I chair the Judicial Council's Accountability Courts Committee, which has heretofore been the committee which oversees the funding of accountability courts when the state grants money to accountability courts. Your question is about what are the components. Well, you have to have the judge, who's the drug court judge or the accountability court judge. You have to have the district attorney or a member of the district attorney's staff as a prosecutor. You have to have a public defender, whether that be from the public defender's office or an attorney who's appointed, by the accountability court, who is funded through the accountability court to serve as the defense attorney for all the participants in the program. You have to have, or you need to have a probation officer appointed by the chief probation officer to sit on the staffing, state probation. You need to have law enforcement at the table, also at the staffing, and you need to have your mental health, your treatment component, and that can be done either in-house if your county is funding that, or it can be done farming it out to a treatment provider through the RFP process, or however you want to do that to get the private treatment provider on board to provide the treatment services to your participants. But those people need to be at the table as well, and any case managers that you have as well who manage the cases. So those are. Is the case manager the traffic cop pretty much that coordinates everything? Pretty much, yeah. Okay. Yeah. Your drug court coordinator, yeah. So those are your players. As far as how those are funded, well, that's part of the DA's job is to be there. The DA signs on to the drug court. The concept. You can't have a drug court without your district attorney. And so they're there. That's part of their job. Your public defender can be funded in different ways. It can be funded by your accountability court if you have enough date funds, or if other funding or your county funding mechanism or state money to do that.
Well, I mean, tell me what y'all are doing now.
Well, in my court, we have enough date funds that we're able to.
All right, tell us what that is.
That's drug abuse and treatment education. It's a surcharge that's added to criminal fines. So if I sentence a criminal defendant, part of that fine, whatever I impose on that defendant, goes to the date fund, and it can be only used for drug abuse treatment education. And in our circuit, we use those funds primarily for drug court, and we are using a lot of that money for our public defender, because our indigent defense office doesn't have enough money to provide for that service. And so we are providing some.
Can I jump in here just 1 second
Sure.
on the date funds?
Go ahead.
We have issues with date funds across the state, and whether we talk about that now or talk about that later, date funds, to me, great use of date funds is to help out with our accountability courts. Many counties, not sure what they're doing with their date funds. We definitely need to do something to address use of date funds in these counties, Mr. Chairman.
Well, certainly if you aren't using it for accountability courts, I know that some counties use it to fund the DARE program or whatever it may be, but to give you access to as much of these funds, because state funds are limited, and so if you can tap into different funds, it certainly helps. Would it be of benefit to perhaps amend the law on date funds to say in a county or a circuit where they have accountability courts that those funds are be used exclusively as a supplement, and then you don't have all these competing interests?
I think that would be very helpful, Mr. Chairman, because in our circuit, we're lucky enough to have a committee that was created years ago, Date Fund Committee, which voted to fund our drug court primarily with the date fund, the date funds that are coming in. So we're lucky in our circuit that everybody's on board with that. But that's not the case in every circuit, as you pointed out. That's just not the case. And date funds are used for a myriad of different reasons. based on your county commissioners and how they want to direct that money. So
Let me ask you this. Is date sort of a county option? Are there some counties or circuits that don't impose the surcharge?
no, it's a state
It's a
mandate.
it's a
When you
mandatory
impose
surcharge.
a fine, part of that goes to a date fund, you know, in
Okay.
your particular county.
There's very little accountability for those date funds, and almost certainly there are counties across the state that are using date funds for things that totally were not intended for those date funds to be used for. If the date funds are being used entirely for the addiction treatment education programs, then I think maybe leaving more flexibility with the counties is not a bad thing, but knowing that many counties it's being used for, well, let me be careful here, but just come out and say slush funds almost in some instances. So whether we decided to use it entirely for accountability courts in those circuits that have it, or whether we just say that it has to just try to more narrowly define how it's to be used, and then where the accountability comes in. But that's a different conversation that we need.
Well, and I guess my suggestion to you, because you're on the joint committee, is even though that's not part of the Criminal Justice Reform Council, I think it's appropriate that y'all look at it, since y'all are looking at legislation.
Question, Mr. Chairman.
Yes, sir.
The date funds, are they, the funds are kept in general funds in the county? Or is it?
No, it goes to, in our county, it goes to a separate fund.
Is that the case? Yeah, I wonder if that's the case in
It's supposed to be. It's supposed to be segregated either in a separate account or at least on the books, because it has to be accounted for under the law.
Question. Also, so is there a general fee set by the date council on that throughout the state? That you have a way that you set the fees?
It's a certain percentage of the fine that I can't tell you. You have to look at the statute to see what percentage of the fine goes to the date fund, but it's whatever it is, it's a percentage of the fine.
Thank you.
All right. Tell me, in the treatment aspect of it, I know that I talked to one state court judge, and he contracts. He's got an accountability court that, may not follow all the parameters, but with the limited resources that he's got, he's set it up, and he's having some good results. And on the counseling and the mental health component, he contracts with the Community Service Board, and they provide some of those services that his folks need. And as I understand it, a lot of their payment, because he's got no money other than date money, and a lot of what they do, they bill to Medicaid, because these are Medicaid eligible patients, and to a great extent, but that Medicaid will not pay for the reports that they have to furnish to the court and the time that they have to go to court and appear in court. And so he uses the date funds basically to offset that. But are a lot of y'all using, trying to stretch the dollars by using Medicaid monies when possible?
Mr. Chairman, Steve Goss from Alden, and you can hand these out. Just this one for all committee members, and I'm going to give Kendra the one that's got the.
Okay.
Mr. Chairman, one thing I'd like to, I'm going to address your question and get quickly to it. It's addressed in that paperwork I've handed you. I do both. I do a drug court and a mental health court. Mainly what I'm here to do today is talk to you about mental health court, because I've been doing it for 11 years. But one thing I think that you've got to understand is about 70% of the criminal justice folks we deal with, whether it's in a drug court, whether it's in a mental health court, or whether it's on a regular felony docket, about 70% of the people in the criminal justice system that have either a substance problem or a mental health problem have some facet of both. And that's a big piece to understand in this. It's what's called co-occurring disorders. Now, where you see some distinction between drug court and mental health court is this. They're very similar in many, many ways. A lot of the same principles, the judicial reviews, the case management, the follow through, the drug testing, etc., is all pretty much, frankly, the mental health court, we plagiarized a lot of what drug courts have been doing because they're about a decade older. But one thing that's important to understand about the co-occurring piece is, let's say, for example, you have a college-educated young woman who's struggling with some depression because she was a victim of sexual abuse as a teen. And she has developed a prescription pill abuse problem as a result of trying to mask and deal with that emotional pain. She has a co-occurring disorder, but she functions at a high level. She's college educated, she's able to hold down a job. Quite likely she'd probably be a better candidate for a drug court than a mental health court because her predominant issue is her drug abuse issue, but she's got both problems. On the mental health side, you have a college sophomore who starts having auditory hallucinations, is diagnosed with schizophrenia, their life starts spiraling downward, they're largely floridly psychotic many times, and he starts smoking marijuana to blunt the voices in his head. He's got a co-occurring disorder. But those two examples are extraordinarily different. The young woman, probably more of a candidate for drug court. Young guy, probably more of a candidate for mental health court because of in a lot of it practically falls out along the lines of how well do they function. To get to the question you asked, now with that backdrop, there are a lot of things that you can Medicaid bill for. My program, my folks all work for the Community Service Board. It is driven by the Community Service Board. But on the mental health court side, case management, and I think Judge Goslin's going to say amen, is the key. And when I say case management with the mental health folks, I'm talking about not just coordinating the court program. I'm talking about, John, do you know you've got a doctor's appointment Thursday? Do you have a ride? Let me make a call to your aunt to make sure she can drive you. And I know that sounds very fundamental and very basic, but with that population, little things are big things. And frankly, some of that you can't Medicaid bill for. And that's a big distinguishing piece on mental health courts, is you have to have case management to close up all the loops.
All right, how are you paying for case management now?
Well, my folks all work for the Community Service Board, so they're Community Service Board employees.
But, I mean, how are they getting paid if you can't Medicaid bill for it?
Out of funds that the General Assembly sends to the Regional Board that sends to the Community Service Board. It is a program of our Community Service Board chose 11 years ago to make this a pilot program and to do this because we were all dealing with the same group of folks over and over and over again. They were treating them at the clinic. I was seeing them at the jail, courtroom. You know, it's not like we went out and rounded up a group of participants. They were here already. We're all just dealing with them in a haphazard fashion.
Judge Goss's program is a little different than ours, and just so you can see how, and I run a mental health court, Kathy Goslin, in Hall County. In ours, the CSB does some of the treatment, and they bill Medicaid for what they are able to do. A lot of the case management, though, we're fortunate enough to have 3 staff folks. We have a psychologist, we have a social worker, and we have a community service worker who's a lower level person. And they provide case management. They also provide treatment where the Community Service Board hasn't. Like the Community Service Board had no trauma groups. So folks that have suffered some severe trauma in their lives, and it was mostly the women in our group and in our court, and there weren't those groups at the Community Service Board, so we started one with our folks. Those are paid for by the county because the county bought into this a long time ago, and those workers get paid by the county. So it's, and in our drug court, which has been long-standing in Hall County, they decided not to use the Community Service Board for substance abuse, and they have their own staff. but that's paid for through fees. The mental health court participants don't pay fees. The drug court participants do pay fees.
And again, a lot of it is level of function. A lot of the folks we deal with in these federal and mental health court programs are so disabled, it's very difficult for them to hold down meaningful employment.
If I could return to the issue of Medicaid and drug courts, you know, yeah, I'm Andy Cummings. I'm the director of the DeKalb County Drug Court, and a very, very small, negligible percentage of drug court participants are going to be Medicaid eligible. That for those you were asking about the Community Service Board, and although the judge is absolutely correct that, you know, like a high percentage are going to be dual diagnosed and are going to need psychiatric services, but most will not be Medicaid eligible to receive those services. You know, I think the CSB system and the system of licensed providers under behavioral health is whom a lot of us work with, and that's great. One challenge that we have is that with the imposition of judicial authority, you're absolutely going to get better results. But a well-functioning drug court is doing more than that as well. And you're introducing evidence-based practices, best practices to dealing with an offender population. Now the reality is, although offenders are in the CSB and being referred to treatment on a regular basis, that the sophistication of the workforce to dealing with the offenders is actually pretty marginal. And the reason for that is that about 7 out of 10 referrals are going to leave treatment within 90 days. Well, the whole idea of drug court is to save 70%, to keep them in treatment, not 90 days, but a year to a year and a half, 2 years. And for the workforce, if you're going to use evidence-based practices, which is, say, a curriculum to drive down the risk of recidivism or something like that, usually the starting point is 90 days for a curriculum like that. So they just haven't had the experience with that, and those types of services are more difficult to administrate. There are costs associated with the trainings. But when we look at real savings, and I think what drives this whole discussion is savings, and savings on the corrections end, that we're going to need to drive down recidivism. In order to do so, there need to be practices that are put in place. The workforce need to be trained to do so. The funding to pay for that, well, the funding doesn't currently exist in most jurisdictions. They either go after grants, they use the date funds or things like that. They use participant fees, and I think as you'd said, that running on fumes, a lot of cases. And so they are resourcing their programs as resources allow. But I think the longer view of this is, if we're really going to get optimal results in terms of savings to corrections and driving down recidivism, we're going to need to resource these programs properly, which is where this $10 million comes into play. It's not business as usual that we're talking about here from my perspective. We're talking about needing to enhance services so that we get the optimal outcomes.
Well, let me ask you all this. Currently, the funding that you get through AOC, I presume that you do an annual grant application. Is that what y'all do?
Yeah. Let me address that, please. My name is Jack Partain, and I'm a felony drug court judge from the Consolidated Judicial Circuit. And I'll tell you a little bit about our process, if that's what your question is.
Well, I guess what I'm doing is number one, trying to educate myself and the other members of the committee. Okay. And right now, like there's currently in the budget for AOC, and you may be able to answer this, is that there's $2 million something in the AOC budget, and I think that's the same thing as it was in 12 and in 13. And I guess my question is that you have to basically re-justify yourself every year and ask for these funds again. Is that correct, Marla? Excuse me. And then when you get these funds, what are they used for? It sounds to me like everybody's sort of doing the best they can, whether it's through county funding or state funding or whatever it is. So what is the state funding is my first question. What is it paying for? And number two, if we reallocate to try to make the courts actually do what they're supposed to be doing, to supplement Dayton, what you're getting from the county, what do we need to do if we sort of divide up this funding and say, all right, we got $10 million. Well, under current funding, that may do 20 new drug courts. But if you want to do it right, you need to fund 10 drug courts like we're normally doing, and we need to put in an additional 50% that a drug court's eligible for to draw down for some of these support services that you're running on fumes on now, as we were discussing. That's sort of what I want to find out from y'all. What's the current money being used for, and maybe how we need to reallocate or reformulate so that the courts we've got can really function like they're intended to.
Okay, I'm Marla Moore, the Director of the Administrative Office of the Courts, and I think I can answer a little bit of that. We do every year within the Judicial Council budget request funding for drug courts. This funding had in the past been subject to percentage increases and decreases based on, but in 2009, when I became the director, that particular year, the all accountability court money at that point was not subject any longer to any of the budget cuts that were being taken by the rest of the agencies. Currently, the lion's share of that money is granted out to felony drug and mental health courts. That's about 1.4 million of it at this point in time, and Judge Partain can talk to you as the funding committee chair about what the steps are that the committee goes through as far as getting those applications, reviewing them, determining how much and where funding will go. That recommendation comes to the Judicial Council then for approval. Another a portion of this money, and I cannot stress enough that there are other models of there are other therapeutic courts that this committee has been dealing with, and I think part of the reason that Judge Lawrence is here is that the DUI courts are generally in our limited jurisdiction in our state courts because that's where so much of the drunk driving, so to speak, comes through, and those DUI courts have had a great beneficial impact. We also have a good history in looking at juvenile drug and family treatment courts, family drug treatment courts. And so while the bulk of what appears in the governor's proposal is that $10 million will go for felony drug courts, that really does impact on the Superior Court, and we would like for you to keep in mind that there are those limited jurisdiction courts, including some successful models in child support and domestic violence, and we've been looking at veterans courts too. So it's divided up that way. There's another amount that is or has been used. We've gotten federal funding, but that has run out. The committee has voted to continue. We do an annual conference each year, which last year over 500 people from all parts of the system come to that for training, and we are again planning that to occur this year in June. So we have 3 employees that are full-time funded to support this effort. We also have other parts of the AOC, fiscal management, that kind of thing that happens throughout the AOC. So we do have support for that. So that's basically what's happening with the $2 million right now. Does that make sense to the question?
It does, but of the $1.4 million that gets granted out to felony accountability courts, what is that money to be used for? And what is the hole that perhaps needs to be filled with, now that we've got a bigger pot of money, to make sure that they're actually not running on fumes?
If I could add something to what Ms. Moore was saying, that actually starting with what Judge Bagley was saying, that the interdisciplinary team that's behind the drug court, which is the judges and the different legal representatives, largely this has been driven by them giving their time on top of everything else they do to make this work. The funded parts of drug court are the treatment, the case management, the coordinator, whoever's going to be running and coordinating the program. testing, and then the other things that are not talked about as much, but which are important program elements, is the psychiatric services, which often has to be funded, 65%, or anywhere from 30 to 65%, depending on your jurisdiction, of participants are going to have some psychiatric mental health issues. Those dollars are often not available. So that psychiatric services, the drug testing, of course, returning to that. If you're going to have an evaluation component that looks at are you hitting the targets, which is going to be critical here in terms of accountability, that needs to be funded, and it's generally funded by the jurisdictions. The dollars from the Standing Committee in the AOC can be used on a discretionary basis to do that, but I would bet that the majority of dollars are going to treatment or to basic administrative operations like a coordinator position or drug testing, and I would bet that's the case around the state.
Yeah, there's something else that, as one who does a drug court, one of the questions I got from you was accountability, which is okay, when they allocate the money, I served a little bit on the committee that we talked about, the drug court's got to put up a proposal, how they're going to spend the money. They make an application. Then the accountability committee allocates based on a whole bunch of different things. When they spend the money, they've got to report back. We require them to report back. I've got to report back on where my money is gone, how I'm spending it, what I'm doing with my money, knowing that next year that committee is going to look at it again. So it's not, I think probably most of us would agree that at this point we're trying to keep alive the courts that are there. And I hear you talking about we can have this many new drug courts. I mean, that's nice, but those of us who are there, we're all scrambling. I mean, I've been doing this for 10 years, and I'm in DeKalb County. We have a wonderfully supported county commission. We also have federal funding. We go after every nickel we can find, any place we can find it. But you got to justify. And that's what I know you're concerned about, and that's what we're concerned about. You got to justify what you're spending, and you got to show that it's good. And that's what I want you to be clear about, that we're doing the best we can, but we need a lot more. We need a lot more, but we are trying to be accountable. I mean, all of us.
Mr. Chairman, I might be able to elaborate
Sure.
on what he's saying. I'm the chairman of the funding subcommittee, and the committee came into existence about 2007 or so in its formal state like it is now. And it's comprised of Superior Court, State Court, Juvenile Court judges, and also some DCAs are on the committee. They represent felony drug courts, DUI courts, juvenile courts, family courts, mental health courts. So it's a composite of all different kind of courts on this, what we call the funding subcommittee. The mission is the fair administration of funds with a view towards program improvement of all drug courts in Georgia. We're trying to raise the level of all drug courts in Georgia, and to have oversight of the, when I say drug courts, I'm used to saying that. I need to get...
We just got added.
I need to get in the mindset of saying accountability courts, because I've been doing this for 10 years. I've been a drug court judge for 10 years. But anyway, with an oversight to try to manage, if you will, the drug courts in the state and improve them. What we did about 5 years ago is we developed an application process, and I've got I'll show you that. And the application, the heart of which there's a formula, and the formula tries to determine whether or not a court is receiving the best value for the money. Number 2 is the court using all available resources. Number 3 is the court providing quality treatment and other basic services. And number 4, are there any other additional needs or extenuating circumstances that the court needs? And number 5, what is the economic ranking of the court? And so that's the heart of the funding formula in that application. We use the grant application, and I'm just going to name a few things, to require courts, number 1, to adhere to the 10 key components. And for accountability courts, that's sort of like the 10 commandments, the 10 key components. we require the courts adhere to those components. We require using the funding application, we require the accountability courts to attend NDCI training, National Drug Court Institute training, national training, so they'll be good, know what they're doing. We require them, for instance, to have observed drug testing, because the court's no good unless the drug testing is observed. Provide a minimum length of the drug court program itself. Adhere to treatment standards, which is very important, and be subjected to random audits. We require random audits also. The committee also provides for technical assistance to courts throughout the state that need technical assistance, and withhold funding if they do not comply, which is one way to get compliance, obviously, is you withhold funding, just like Judge Castellani said. Every year we review these applications. And we've also developed an online grant process, so that application that I just gave you is online, so it's much easier to process. The application also provides for a collection of and analysis of statewide data. And I've got some examples here for you to show you what we've gleaned from the application process for DUI courts, felony drug courts, family dependency courts, and juvenile drug courts. And I'll give you a copy of that. We also, as Judge Castellani
Why don't you go ahead and hand it up while you
Sure. That information was gleaned from the application process. And we also require quarterly reports. The drug courts throughout the state that receive funding have to report on a quarterly basis back to us. And here's it's not a small report. And that is the report that we require that they submit to us to make sure that they're using the funds properly and doing what they're supposed to do. So there is an oversight committee, it's a funding subcommittee, that is pretty much charged with raising the level of drug courts in the state of Georgia and making sure that they are in compliance.
If I could interject, you're talking about funding. Funding right now, 2/3 of the funding for accountability courts comes from the local level. So the 2.2 is definitely appreciated, but the bulk of the funding for accountability courts comes from a local community. Actually, the boards of commissioners across the state have actually put in the lion's share of the funding for these programs. That's resulted in a patchwork of programs across Georgia where funding ranges from approximately $1,040 per participant up to $10,000 per participant. We've identified approximately $7,300 per participant is what's needed to have an evidence-based program or process using best practices so that you maximize your potential outcomes for the individuals going through these programs.
Okay.
Mr. Chairman,
yes,
maybe from the mental health side,
try to get close to the mic.
Judge Partain mentioned the 10 key components, which is sort of the guidepost for drug courts nationally. I've handed Kendra the 10 essential elements for mental health courts, which is the similar document. But one thing I would like to mention from the mental health court's perspective, the movement is 10 years behind the drug court movement because they're a decade newer. The data piece is something we're just now starting to build the data sets, because ultimately what you want to know is information about cost avoidance. You want to know if we appropriate Y amount of money down the road, how much savings are we getting in corrections budget, in the state hospital budgets, etc. That is a very difficult problem, particularly folks struggling with mental illness, is because these probationers, participants, consumers, whatever nomenclature you wish to use, they impact so many disparate budgets. The indigent fund locally at the emergency room, the county jail budget, the sheriff's budget, the state hospital budget, the state prison budget, and of course, like I said, some local, some county, some state, nobody interconnected IT-wise. So that is a challenge we're working through right now, is to try to be able to track You know, if we take a participant and we reduce their recidivism by Y%, what's the ripple out into corrections budget, state hospital budget, et cetera? That down the road is what I suspect folks in your positions are really going to want to know. But we're not quite there yet. We're working on it, but we're not quite there yet. Not just in Georgia, that's nationally.
Okay. Judge Pridgen.
Chairman Powell, of course, the charge that y'all have is,
Get a little bit closer because
All
we're
right, see
getting
if I
some
can get a little bit
complaints that
closer
they
to
can't hear them online.
the charge that y'all have is the allocation of these new resources, and you've got some very successful operational drug courts out there that have specific needs. Then there's the other part of Georgia. I represent the have-nots. There are 13 circuits in this state out of 49, my circuit being one of them, that have no accountability courts. We have little or no resources. We have almost no treatment options available to us. When they start talking about date funds, the sheriffs, and I see Terry Norris was out there somewhere a while ago. I got a sheriff that's he's gonna have a duck fit when I start talking about using some of those date funds that he runs his DARE program out of. So there's gonna be competition for the local dollars in addition to the state dollars. The hard decisions that y'all are gonna have to make is what's the best allocation of this money. It's not gonna be enough to do all the things that everybody wants to do. Is it going to be better utilized to strengthen the courts that we do have? Is it going to be better utilized to try and create some component everywhere, or some hybrid from that? But I suggest to you that when you get into the rural areas where I am, it's going to be tough because I've got a 4-county circuit, small counties. I got those 4 counties in 3 different catchment areas for social services. And none of those have an office anywhere in my circuit. So we're red-headed stepchild of everything and everybody. The fact that we don't have a drug court is not because we don't have the zeal to do it. But it doesn't do us any good, and you and I've had this conversation before. It doesn't do me any good to throw a bunch of money to create a court if I don't have the treatment options and the infrastructure to be able to make it effective. And if it can't be effective, I don't really want to do it.
And you're right, we have to make the decision, but we don't need to make the decision in a vacuum, which is why all of y'all are here today.
Right.
Because y'all been in it, and you know, some are rural, some are metropolitan. I know Judge Goss and I've talked about the fact that you know, it very well may be that it makes sense to spread out from existing courts because they do have some of the resources that you can piggyback on while you develop your own resources. Those are the kinds of things that y'all need to tell us so that we can make the right decisions, because we don't need to waste this money. This is an opportunity, and we need to make sure we use it wisely and we don't spread it too thin. If we need to support the existing courts and expand out a little bit from them, or whether, you know, we need to go and try to spread it out and do DUI courts at the state court level. I mean, that's what we're listening to y'all, and we want to make sure that we do this right.
Mr. Chairman, one thing I'd like to mention to sort of follow up on a conversation we've had in the past and what Judge Pridgen just said. My personal view is not every county in this state needs a separate accountability docket, because there's many counties, as Judge Pridgen just mentioned, that don't have the volume and don't have the treatment services, don't have the transportation to get people into treatment on a routine basis, because they don't have a bus system or MARTA or anything of that nature. I've attached to the paperwork I've handed you a color copy. This is called the Gaines Center Sequential Intercepts Model. It's fairly standard in the field. And what it does is it maps in any criminal justice system in this country the 5 places that people with drug and mental health programs typically interface, whether it's in the field with the police, whether it's at the jail booking desk, the courts, or corrections. From a mental health perspective, the view is that there is no one single point that's the magic answer. It's a continuum. This may well be beyond the scope of what we're here about today, but I think it's got to be part of the discussion moving forward, is that in many of our rural counties, maybe the smart way to approach this is to work with someone such as state probation, state correction, Mr. Cooper's here today, to try to develop programming that they can deliver into a county, into a rural jail, into a rural circuit court. They may only have 3 or 5 of these cases a month, but they really need help with those 3 or 5 cases a month. That, again, that may be beyond today, but I do think as we move forward in Georgia, that needs to be part of the discussion. Is not just we need to strengthen these courts, because these courts do very fine work where they're applicable. And but there are just going to be some places that that's not going to be the delivery model that's going to make sense.
Which is why I hope that
I like what you're saying. I have a question. When you talked earlier about the 2 examples and how totally different those 2 examples were, and I hear you talking almost as if you're a mental health provider as you're talking about their diagnosis, and obviously you have an understanding of what those even though it takes a lot of training to get to the point to where you fully understand, but you have enough of an understanding of those circumstances to recognize that difference. When we start talking about some of these circuits where you're looking at trying to deliver into a circuit from probation or corrections or somewhere for a few cases, how difficult is it to get those judges in those circuits that don't have at least a little understanding of the mental health population to acknowledge that there's a need here other than just exercising judgment?
What you want to
Well, we can both do it. I think that there are judges that realize that there's a problem and want to do something about it, but are completely don't know what to do because they don't have the resources, they don't have the things available. I think if you give those judges the creative opportunity to build some alliances with both corrections and with Department of Behavioral Health and Developmental Disabilities, that they can come up with some ways to handle folks that have mental health issues or have co-occurring issues in their community that will address the needs. And it could be as creative as having a person that understands those issues, not the judge, be in the courtroom. And we've talked about some of that. Ellen's out there, but there's some places have talked about using a person that was trained as a social worker or whatever who could direct the court. This is where there's treatment. This is what's wrong with this person. This is what the options are in your area. Maybe working with the prisons to work on some of their counselors, being at probation offices to do some treatment groups. There are a lot of creative approaches that could be done in the more rural areas, and I hope that some of this money can be used to try out some of those in pilot projects. So.
I think what I've observed over the last 10, 11 years that I've been doing this is I think
Get close to the mic.
Judges, we're very practical people. We read about something, but when we start seeing a colleague or a friend running a program, I can almost assure you that people in Judge Partain's part of the state have come over to talk to them about, okay, how are y'all doing this in the Dalton area, or Judge Bagley, or Judge Castellan. All of us have had people say, well, they're doing it, maybe we can do this. So I do think incrementally, to answer your question, some of it just takes time, and I think that's where we are now in the state 10 years later, is we're having more and more of these programs started because people have gotten a greater comfort level to it's deliverable under the right set of circumstances. They've seen other communities doing it.
I'm Judge Downs, and I'm from Fulton County, and I've been a drug court judge now for 10 years also, and I was a prosecutor for 14 years before I became a judge in '96. And I got into the treatment courts not knowing anything, just like you said. But I did know that what we were doing wasn't reducing recidivism. And I was doing the same thing every day, sending people for $18,000 a year to prison with an addiction. They got back out with $25, a bus ticket to Atlanta, and their next hit of crack cocaine. And I got sick of being a part of the problem and wanting to be a part of the solution. So I jumped in there, not knowing anything, and started educating myself. And the people that educated me the most were the drug addicts that came before me every day. And I was cheering some on and punishing others, but they would tell me when I was doing right and wrong, and so would the treatment staff. I follow the treatment staff recommendations 97% of the time, probably. Sometimes I think they're a little too harsh, and maybe we need to do some more positive things rather than negative things. But the bottom line is that about 10 or 12 years ago, a whole bunch of these judges that are here in this room got together and said, there's got to be a better solution. This Get Tough on Crime is just wreaking crime and havoc in our communities, and it's killing us. As judges, we're just working as fast as we can, getting nowhere. So we have an obligation to our community to try to make a difference. So we jumped in there with nothing, and we went to the Department of Corrections and says, I've got a prison full of people over here. I can do something better than you can with them with some treatment. I went to the housing providers. We got 600 people in Fulton County Jail on psychotropic meds. You've got 590 beds, forensic beds in the state of Georgia. You know, we've gone to Morehouse. We've gone to everything that we can go to. The county, we've had great success. But there's so much more we need to do in Fulton. It is a drop in the bucket, what we're doing right now. But we're doing a lot more than we did 10 years ago. And we're having great success. With burglars that have repeat burglarized. We get them in treatment after sending them to prison over and over and over. And 13 months later, they're supporting their families, taking care of the children, helping their elderly mothers, working, appearing at the community. I go introduce them back to their community after we finish. It is win, win, win. It's cheaper, more effective, reduces recidivism, and makes your community safer. So as I got sold on it, that's what happened. I didn't know anything about it. When I just wanted to do something different than what we were doing. And so are these other judges. They are very similar, and we have shared and worked, but each one of us has a completely different court because we have a completely different scenario of elected officials and funding and everything else. But a lot of the funding is people like me that just give whatever time they can to it. I don't get extra pay, and neither does any other judge here. And you pull a probation officer in that's already being paid. You pull a DA in that's already being paid. You know, you just say, divert your resources to us. We'll make a difference. Let's watch it.
Thank you. I personally have a similar story where I just saw clearly that what we were doing wasn't working, and turned 180 degrees from the direction that I used to feel about dealing with these offenders. And I applaud all you all because you all were the ones out there on the front line beginning to make these changes when it just wasn't happening yet. Now we have a lot of evidence-based practices, and we have a lot of with sentencing and corrections and treatment to where we know what works. So we're not, with our criminal justice reform and what we're doing with our accountability courts, we're not plowing new ground. We're not rolling the dice and hoping that what we do works. We're building upon evidence-based practices that we've proven in Georgia and has been proven in other areas of the country. And clearly we have to move in the direction we're moving. Now I want to ask you a question to take this a step farther. You're doing a lot of really good things, no question about that. And you're reintroducing people into their communities, a totally different person than they came to you. Are you doing anything with continuum of care, aftercare, with those individuals to make sure that they continue to be that different person in the community? Because, quite honestly, addiction is a lifelong disease that has to be treated on an ongoing basis for those individuals to stay in recovery. Absolutely. And as we've already talked about, so many times they go hand in hand with the co-occurring disorders as well. But you do?
Well, we don't do what we could do because we have to turn it to the people that are actually in the program. But we do tell them, you must attend meetings for the rest of your life. This is not a cure. This is living in recovery is a choice. And when you have triggers, you're going to have to come back. You're going to have to get more. And we have had people come back to our drug court program. And we stay in touch to the extent we can with our graduates. With our mental health group, there's where the real problem is. We've realized that trying to treat within and then send out into the community, graduate people, is a huge mistake. There's no such thing as graduation, so we don't even say the word anymore in mental health court. We try to get the ACT teams involved, the assertive community treatment teams involved with treatment immediately, so that when we turn them over, they're with those people that they've already been with, instead of turning them over to somebody new. And I tell them all that if you get in trouble, come back to my court and I'll do what I can for you to try to find more help. But we don't have enough, you know, to give a real effective follow-through, is what I can tell you.
Representative Neal.
Yes.
Let me address one thing concerning that. As a drug court judge, one of the most frustrating things and heart-rendering things is when somebody who's graduated from your program screws up.
Mm-hmm.
I mean, it's like your children screwing up. You've dealt with these people for 2 years, and then they get out and everything's happening for a while, and then they mess up. Fortunately, we've graduated 159 participants, and we've only had 10 be rearrested within the first 12 months after they're leaving. So that's a pretty good stat, I think. But
Yeah, I don't think anybody's going to argue that.
yeah. But what we've done in that area is we've established an alumni group, and our alumni group is run by the participants themselves. We don't get involved, and they meet on a monthly basis, have dinner, and that's the only thing we've done. But that's something. It's very difficult to manage folks when you don't have any authority over them.
Mm-hmm.
When they graduate, you can't manage them. You just have to hope that they want to participate in these alumni groups that we provide for them.
One of the things that I hear sometimes in the community, people will point out that individual they know that it didn't work with, and clearly, accountability court's not 100%. We're not going to succeed with everyone. I'm a campus director of a 6-week residential treatment program. Some of you all send folks to the program that I'm with. We have great success, but we don't have 100% success. So one of the things that's important for people to understand is while we may not have 100% success, when you look at the success we're having with offender population in accountability courts versus the offender population that's not in accountability courts, there's no comparison to that success rate. It's phenomenal, the difference, and we have to realize that we can't let perfect be the enemy of much better than what we have. So we'll not be able to reach perfection, but we're gonna far exceed what we've been doing as we move forward with this.
And a lot less than $18,000 a year.
Chairman, my name is Kent Lawrence. I first would like to echo everything that Dan just said. I went on the bench in 1985, and for the first 12 or 15 years.
Get closer to the mic, please.
12 or 15 years.
This is yours.
I was seeing the same offenders over and over in court. We were doing nothing to change their lifestyle. Our population of offenders has, since we started an impaired driving court program in 2001, we take second and subsequent offenders into our impaired driving program. We know that the high-risk repeat offenders falls approximately 35% of all the alcohol-related and other drug fatalities across the state. They're a high-risk population that at any given time are subject to causing serious bodily injury or death, not only possibly on themselves but others. But I would like to say that we've made tremendous progress. We were the first program that started in Georgia in 2001. Our program has now grown to where we have 22 impaired driving court programs operating around the state of Georgia out of 159 counties. So we have a lot of growth to go. I recently retired on November the 30th because I was selected by the American Bar Association and the National Highway Traffic Safety Administration to be the Judicial Outreach Liaison, which is a long name for JOL, but to handle the states of South Carolina, Georgia, Florida, Tennessee, and Alabama to continue to facilitate the growth of the impaired driving court programs in that area. Of course, Georgia is close to my heart because I've been in the state as a judge for now 26 years. But one thing is that our research, and we had 3 pilot courts in Georgia, Chatham County, Clark County, and Hall County, that the research clearly shows that the recidivism rates are far better than those people who were in other groups. And we had 2 other groups, a retrospective group and another group, excuse me, but, excuse me, but the recidivism was far better than those other outcomes that we saw based upon the NHTSA research that they did. Our retention rate of participants in our program was 79%. We'll put those statistics up against any program in the country. But these programs have continued to grow, and we were designated in 2006 as a National Academy Court program, and we've been training programs from around the United States in Athens since 2006. We'll have another group in April from around the country, and then we'll have in August another training program for Georgia courts that we hope will have at least 4 or 5 Georgia court programs will be trained here. So we're trying to continue to grow, but one thing that all courts are faced with are sustainability issues of programs. Once you have your program in place, does not necessarily mean that you don't need additional resources, because that's a continuing process. And courts have to be pretty creative. They have to go out in their own local communities and find out what resources are available to be able to bring people in that might be of assistance to the program. We have a situation in our program in Athens that a year or 2 ago we had a gentleman who used to be at the pharmacy school, head of the pharmacy school at Athens. He retired, and I was just talking to him one day. He decided he wanted to come in and be our expert in terms of dilutes and adulterants and things like that, and he's been an active member of our team for the last year and a half to 2 years simply as a volunteer. So you have to continue to be very creative. Fortunately, our program, we've come a long ways in terms of being able to identify resources that we are a self-supporting program. We only pay $20,000 a year, and our budget's around $380,000 a year. And so I think you have to have that type of initiative if you're going to be a judge of any program, to always look out. And not all communities are the same. I agree with the judge that you don't have many resources at all in your area. But it's kind of like the field of dreams, as I said. If you don't have treatment, if you'll bring a program to your community, those treatment clinicians will come because they want the money. They want to be a part of the problem. So I just wanted to share that.
Let me ask a question of Judge Partain and Marla. In the existing, and basically, I guess my initial concern was $10 million for accountability courts doesn't tell us anything. But I think what I'm hearing from you all is that y'all are taking applications for grant monies, and I may say that I need X number of dollars for a case manager, and I need Y number of dollars for some expert assistance, whether it's counselors, and that every community is different, but that when you fund a grant, it's taking into the individual needs of the court that's setting up that program. So we don't need to divide that money up. Is that what I'm hearing?
I agree. Yes.
Okay. All right. My second question is, and y'all also fund these applicants based on how much they bring to the table. If you can fund $60,000 and it leverages into $380,000 that is community-based, you're going to be more apt to fund that program than if I come with you saying that I need $440,000 because I'm not willing to put up anything locally.
Absolutely.
And so you're already stretching the dollars.
That's what we do.
Okay. Now, did I also understand that y'all are doing some state court DUI or not?
Oh, yes. The state court, DUI courts, also in juvenile drug court and family treatment courts. We have a couple of mental health courts that are actually operating out of a probate or a magistrate court. I mean, there are other levels of accountability is where we are using, building on the model, as I said, doing pilots. There's another thing I would like to just bring up if you'd let me. I do have a map here which shows where the current felony drug courts are located, and also where we have some ones that are moving forward. They're already taking the training or have requested technical assistance in order to get on the start of it. But I would also like to note that we have, I believe, 5 members of a state team that we began last October looking at some circuits where they did not have a drug court, and what were the impediments to them, and what kinds of things could they do if they did not have the resources or whatever in order to actually go into drug court. And one of the things that our state team particularly identified was an assessment tool on the front end. And I think Stan Cooper, Judge Goslin, I mean, we have been working on that, have a meeting actually scheduled for next week. Representative Neal is on that as well. So I'd like to give you this map, but also tell you that I believe that assessment for and determining how soon we can get that into the system, so we can determine, if this person has a need that can be diverted into some sort of treatment program. So that's another issue that I think we should make sure we keep on the table when we're looking at the funding, because that may that effort could certainly be helped.
And that segues into what Judge Goss was talking about, whether you're dealing with the Department of Corrections and maybe using some of their facilities to do a drug court light through the jail system or whatever. Are y'all looking at some of those possibilities? Because certainly there are communities that don't have the resources but could benefit from whatever little bit that we could do.
Right. The state team had corrections on there. We have community service board person. We have people from mental health.
DBHDD.
Yeah, DBHDD. I never can remember all those letters, but anyway, like I said, it's a 10-member state team that is made up of really representatives at the state level of the components that we're talking about in the need of these courts.
Representative Powell, there was a symposium back in October, and I think there were 8 circuits, and they tried to get a Duke's mixture. Our circuit was one of the, as I said, we represent the have-nots, and we sent a team of 5 people. We sent one of the judges, somebody from the probation department, the DA, the public defender, and someone with administrative. And again, to give them an example of the challenges if you try and go everywhere. And again, the first thing is the assessment. I mean, so I think we're probably part of what she's talking about. So there is a process of looking into the rural areas to kind of say, well, where do we begin if we want to try and do something, and how can we best do what we can, whether it's in just the largest county within, say, a multi-county circuit. Because you get some counties, as Judge Goss indicated, that simply, if part of this process that we're looking at is to reduce our corrections cost, you're not going to get much bang for your buck in Wilcox County. You're going to get a lot more bang for your buck putting your resources in those counties with higher populations and higher offender populations. So, I mean, we got to be realistic about what we can expect in the rural areas, because we don't have the impact on the overall cost that you're looking to save as the larger areas do. So,
I think you can add. I think you can add another thought to that as well, though. We are looking at saving money. There's no question about that. But probably more importantly is we're looking at giving these addicts and these these mental health offenders an opportunity to be able to live productively in society. And if we're able to do a statewide drug court system that ultimately saves us money statewide, and it does so by saving a lot of money in in urban areas and breaking even in rural areas, but we're giving opportunities to people across the state to be able to get the services that they need and the help that they need to be able to be productive members of society, we can't rule out that. We can't look at just circuit to circuit and say we can save money in this circuit, but on this circuit we can't. So we can't. I wouldn't want us to take that approach either.
Well, they can always commit their crimes in urban areas.
Right.
Well, Mr. Chairman, one thing that Representative Neal touched on a moment ago that the assessment piece is so important is never lose sight of these are intensive programs. You know, I know a lot of people in the general public say, oh, well, you want to send them to drug court, you want to, you know, make everybody feel good. Well, they're intensive programs. Frankly, I suspect most of the judges will concur. You get people into the program, and at first you're catching them failing drug screens more frequently because you're testing them more frequently.
I have more people decline than I do join drug court because it's too hard.
It's the hardest thing they'll ever be asked to do. The hardest thing they'll ever be asked to do.
So they're very intensive, and part of the thing I want the General Assembly to have a realistic expectation about all of this funding is how you define a win. If somebody never gets arrested again and stays sober the rest of their living days, then obviously everybody agrees that's a win. But we're largely dealing with a high-maintenance group of folks here. They're high utilizers of human resources, of court time, of jail staff time, sheriff's time, DA's time, etc. And they're also big dollar users at the state hospital and the state prison system. And so I submit to you, you know, we don't want to set these things up so that you're just you're cherry picking. You're taking people you think are going to turn out very well because you want your numbers to look good. We want to be addressing the right target group of folks because that's where you're going to get the most savings on the back end. And a win may be, yes, staying sober forever, but a win also may be for a person who is averaging 3 stays in the Dougherty County Jail a year at 40 days apiece. If I reduce that to 1 time a year for 30 days, in other words, I widen the gap of time between the episodes and I reduce the severity of the episode, I submit to you that also is a win. So I just think that needs to be part of the discussion is what are expectations.
Absolutely.
And I'd like to add that it's judges like Judge Goss, like Judge Partain, like Judge Bagley, these judges' committees that make the decision who gets the money, hold these courts accountable. They are experienced judges that know programs, know what they should consist of, know what the proposal that you're making to get the funding, whether it's going to produce something, and it's not always a happy ending, but everybody's been willing to accept the decision of this group of experienced people, and I think it's been a good way to resolve issues within the judiciary.
Getting back to the assessment component and the cherry picking, is that component in place now or going to be in place so that there is a mechanism for determining whether our courts are cherry picking or whether we're using the proper assessment, picking the right target population?
Let me speak to that. One of the things that we did in DeKalb County when we started the program was to make a decision that we were going to target the biggest users of the criminal justice system. So we got repeat offenders. That's what we looked at. There's a lot of resources that are invested in this program. It doesn't make any sense to me to have a first-time user going through a program like that. So the way that you try and get whether these people are doing what they need to be doing is the assessment. That we learn very quickly if somebody's got some mental health issues that are really bad, we need to know about it. I will say that we have tried virtually every assessment tool that we're aware of, and they all stink. I mean, they do. I mean, some are better than others, but trying to assess somebody's ability to be able to go through a cognitive-based treatment program is really difficult. We're getting better at it. But we as a team, have decided we're going to do the best we can, and we sit around and discuss who's a good candidate after we go through the assessments. But our decision, and I think most courts want to take people who are going to have the biggest impact on the criminal justice system. There's one other thing I want to say that I hope this committee understands, is that drug courts are different because we're collaborations. Everybody's used to the court system where the judge just strikes a gavel and everything happens. Drug courts are collaborations. We listen to everybody else. We learn from everybody else. So when we make applications for what we need, the team has sat down and talked about it. And you build, like everything else, you build credibility based on your performance. And so we are evaluating constantly what's going on. It's a great feedback mechanism. Right? In the second row there, we've got Dr. Wendy. She is from Georgia State. She's an expert in this area, and we've asked her to come in and evaluate our program. And she's become real knowledgeable. She can give you facts and figures about assessments, about success rates, about all kinds of things. But we want to make sure that you're aware that we're spending our money wisely. But I don't mind telling you, $10 million, it's great. It is phenomenal. It's a wonderful commitment. It's a drop in the bucket. It's a drop in the bucket, and everybody here, we know that. We love it. We love that you're doing that. We're grateful for it. But boy, do we need more.
Chairman Powell, if I may. I'm Stan Cooper with the Probation Division with the Department of Corrections to kind of answer your question as far as the assessment and where we're at with that. So right now it's in the mode of researching with ARS, Applied Research Services, who's done tremendous work in the state of Georgia, and looking at what it's going to take to develop that risk or that assessment, if you will. But just to kind of give you an idea now, the assessments identify the needs of that offender, and I think that's critically important. That in the past we've addressed just risk in this state a lot of times, and not addressed the needs of that offender, which really is the underlying factor of many of their criminal activities. I think the move now, and Marla talked about this state team, and there's a lot of great work coming out of it, is that has been identified that we need to build a risk assessment, needs assessment on Georgia's population. So to give judges, to give prosecutors, to give the legislature and others the information they need to make great decisions or good decisions about that offender. So it is really just in the working stages right now, sir, and that's where we're at with that. Going back to something I think Marla talked about and Judge Goss talked about as far as corrections in these rural areas, and we are researching, and that was brought up and asked of us by one of our judges in the rural areas to research the possibility of using our counselors from the prisons to conduct some treatment, and we're currently looking at that. And there's some ideas that we may be able to do some in the area, such as Judge Pridgeon's and other areas. We're, just to kind of give you an idea, right now with probation officers, I have over 55 probation officers right now that are involved in our accountability court statewide. And they do a tremendous job. And listen, we see every day the impact our accountability courts have on not only our probation population but the prison population. And so we know they work, and we want to do more. But it's important to understand, and I think everybody is saying that, this is a team effort. It's not just one component. It takes everybody working hand in glove to make it not only successful, but help impact that offender's change in behavior so that we don't see them in our expensive prison beds. So just to kind of give you an idea, the risk assessment is something that has been talked about in the Criminal Justice Reform Council. You can't ask a judge in this state about information that they'll tell you they make better decisions if they're provided better information and more information about that offender. So that's kind of where we're at with that.
And one of the reasons that that's so important is when you have courts that are cherry picking, sometimes those courts that are cherry picking are getting offenders that are harmed by being in the accountability court rather than helped by being in the accountability court. So when you're able to do those assessments and understand that some of those we're cherry picking are the ones that don't need to be in the courts at all, they need to be they probably need some type of a pretrial diversion and need to be in with a little counseling and as little involvement in the criminal justice system as possible for some of those. So that's an important reason to look at that as well, not just making sure we get the right ones in, but that we're keeping the right ones out too.
And let me speak to that, Mr. Chairman, talking about going statewide with accountability courts. This money is going to help us to do that. We as an accountability court committee for the state have a unique challenge in that we're going to have to develop more detailed state standards. 10 key components are what we've been living by. I've been a drug court judge since 2004, so that's 8 years, going on 8 years now. And that's great, but there are some judges in the state that need more detailed standards. We don't want to have a situation happen again like we had recently in the state, and we all know what I'm talking about. And that's the reason that we want to, and we're going to develop more detailed state. We're going to drill down the 10 key components. We're going to get more detailed about our standards, so that these accountability courts are going to have to be accountable. If they're going to take advantage of this money, we want to make sure that they're living up to the standards. Now,
let me interrupt you just a second, though. But do you think, I mean, we're getting, I read an article not too long ago about we over-regulate and we basically try to regulate everything, and what we wind up doing is we regulate innovation out of the system and innovation, and that bothers me. What we ought to be looking at is basically some parameters and some accountability. We expect these kind of results, but do we really want to set, if you don't do it A, B, C, D, E, I don't care how successful you are, you don't fit into our program. And we've had, I think Judge Goss and I've had that discussion too, because there aren't even recognized national standards for.
Well, on the mental health side, now the drug court movement is 10 years further down the rail.
Right.
Yeah, I'm on the NADCP board, the national board, and there are going to be standards, but they're 2 years out. We don't need to wait 2 years. We've got all this money that potentially could be coming. We want to make sure that we're accountable. To answer your question, the challenge for our committee is to, yes, have the standards drilled down to be more detailed, but to still make them flexible. Because talking about assessments, and you're really talking about target population. What is going to be politically acceptable in Judge Downs' community is not going to be politically acceptable in my community. It's just a fact. Your district attorneys, who are your gatekeepers, are not going to accept people, in my court that they might in Fulton County or in DeKalb County. It's a different. Judge Castellani is talking about high risk, high needs, and that is the evidence-based practice to show us that you need to have high risk, high needs people. That's what you're going to get the most bang for your buck. That means multiple offenders. So it may be okay in DeKalb County to take a 5-time felony offender into drug court. It's not going to be okay for my DA in Forsyth County. It's not going to be politically palatable. They're not going to do it.
If it's shoplifting or something, if it's not
right.
violent.
But what I'm saying is no violence.
Sure.
But there's going to be different community standards for what you can, for your target population in different communities. It's just going to be that way. So our challenge is to, yes, drill down and create more detailed standards, but leave it flexible, as you say, for the different communities to be innovative in how they're able to work within their political climate in each of their communities. But that's what that's our challenge, and we're going to work toward that by June, by our conference in June, to have those standards nailed down, at least, potentially, so that we can have that in place when if this money does come, we'll have something to be able to say we're satisfied that we're not going to have some court that is a rogue court that we're going to have to answer to the public and say, well, where did this money go, and was it spent in a wrong manner? We don't want to have that happen.
Mr. Chairman, to echo what Judge Bagley is saying, I think we can do both. I think we can set guidelines that that make sense and they're based in evidence-based practices and make Georgia a leader while at the same time incenting innovation, because it's going to take all sorts of different approaches to make this thing work, and we don't want to lose that. And I see it as setting benchmarks and guidelines and then allowing the practitioners, allowing the judges in their circuit, in their jurisdiction with their target population to decide what's working. But we've got to have we've got to have consistent data. What they're collecting in one jurisdiction has to be similar in what we're collecting in another, so we know what we're talking about in terms of risk and in terms of needs, and we know more about our courts. And that, to me, it gets me to a somewhat unpopular but important point, and that is that we're going to have to resource programs to do this. Assessments, and there are really good assessments. The best assessments are proprietary. They're not free. They're $8 to $9 a pop, whether you're using them in corrections or you're using them in a court. And we are going to have to resource this and provide a level of oversight. And the $10 million represents a complexity that's unprecedented. I have complete confidence in our ability to do it, but there's going to have to be oversight. We're going to have to, as much as people don't like to think about administrative costs, like we're going to have some additional costs that come along with this to make it work. I'm quite confident in that. And you know what Judge Pridgeon was bringing up, I'm really sensitive to that. Like, it doesn't make sense to necessarily have a drug court in every jurisdiction, but we need to provide support to those jurisdictions that are interested in doing so and help them do a needs assessment, help them do a resource assessment, and give them some mentorship, and we need to prioritize that as well. And so we get to a place where we got to do two things at once. We want to enhance and raise standards. We want to be not talking about apples and oranges and using assessments that make sense for us. And Judge Bagley is a strong proponent of that and where we're going with that by the June conference. But we also want to bring new jurisdictions online, and we can do that. We can do both. It's just it's a big lift, and it's a complex lift.
I'd like to ask a question for Ryan Teague, if you don't mind. I don't want to put you on the spot here, but we're here because of the governor's leadership and the governor's interest in looking at spending dollars in a more efficient and effective manner in the criminal justice system. And we're hearing a lot of discussion about what we need to do within the existing, I guess, the grant infrastructure, if you will, of how we're spending and resourcing dollars to the limited dollars to the accountability courts. And we're about to create a significant infusion into that system. From the governor's perspective, and the governor's office perspective, are you satisfied with the existing infrastructure that we have, the oversight and the manner in which these grants are being parceled out? Or as a state government, whether it be from the executive branch or the legislative branch, are there additional steps we need to take to make sure the money's being spent the way the governor intends? And I guess that's a question there. How does the governor see this money being spent? Does he have any ideas? And B, do you have any guidance from his office for us as a subcommittee?
First of all, I just want to thank all of you for having me. Managed to try to stay quiet, not answer any questions until they're asked of me. But thank you for having me. And the governor's very appreciative of the leadership that all the judiciary has taken on developing these drug courts. We know that your leadership is why it's where it's at now. I think I'd step back from your question just for a little bit to give you the kind of the holistic view that we have from the governor's office perspective about this process. Is that last year with Jay Neal and others, we took a step forward to try to have a comprehensive review of the sentencing reform idea and see what we could do to quit the recidivism, reduce the people that are in our prisons, and that is a wide spectrum. But we realize that if we go out and take aggressive reforms, which we're committed to, and we'll be bringing those forward very soon to the legislature, we need to have a backstop that the accountability courts have provided to help those people who are not otherwise in prison. They need to have some provision of services that these type of courts provide in order for us that broader spectrum, that broader view to be successful. So that is I say that because to give some perspective as to why the governor decided to put $10 million in the budget to do this, is that when we were sitting there going through what are our policy proposals for the year, and the criminal justice reform package is a major concern of his, we knew we need to make an investment in making sure that full system worked. And the $10 million represents his view in building that up. As for the way that money's spent, we haven't been, the governor has a very strong view in local control and letting the locals make a decision of make what they have best fit themselves. And so we didn't have a very detailed view, but where we've come down is we'd like to be in a collaborative mode with the judiciary to spend that money in the most appropriate way. And we've been talking, and I will say that, and I can let Marla speak to what the AOC would like to say, but we've been working together to try to come up with a best model. I don't think that we're there yet completely, but we're working on it, and I feel confident we'll get there.
Is that model something that's going to require legislative action, or just as a procedural question?
I don't know yet.
Okay. Thanks.
But what we've been able to tell is that the funding committee that y'all have set up and used has been very successful, and it's been very instructive, and we don't come at it from a critical approach at all. But we do recognize this is a major infusion of money compared to what that committee has been.
To follow up just a little bit on that, have you had many conversations about, with this $10 million, how much of it you would like to see shoring up our existing accountability courts, how much of it implementing new courts, beginning those processes? Have you had those conversations?
We've had those conversations, and I wouldn't say it's black and white.
Mm-hmm.
The governor has definitely been very supportive of the idea of having a drug court in every district in the state.
Mm-hmm.
We realize the limitations of doing that, and that you need to have the services available to provide to make that successful. So we're not blindly going in and saying this is the way this has to be done, how it has to be done. So I think where we would come down is that we would like for this committee to have the right people, the collaborative approach and the committee that we end up being able to use, have the right people to make the right decisions there, to have the right mixture, which would be, I think, we're not opposed to that money shoring up existing drug courts, but we are very much in favor of expanding the accountability courts out there. Accountability courts, which covers the mental health and everything else.
It would appear to me that that if we're going to do this right, and I know the governor, let me just say this: the leadership of our governor in this, the criminal justice reform, the expansion of accountability courts, and the things that we're trying to do here in the state of Georgia, the leadership of our governor is phenomenal, and what he brings to the table with his leadership, I'm not sure that we can thank him enough for what he's doing, and I appreciate him being willing to, first of all, understanding the issue well enough to where he's able to embrace it with the kind of boldness that he's embraced it with, and I applaud the governor for that. As we move forward to try to take this accountability approach across the state as much as possible, shoring up the existing accountability courts is, in my opinion, a vital process of that. And part of the shoring up of the existing accountability courts is making sure that we have the community treatment pieces in place. And I would like to, if we could, Mr. Chairman, I'd like for us to talk just a little bit about how some of you all handle as you begin the process with those who first come into your court, entering into your accountability court, the assessment, the treatment, who puts together the treatment plan, who monitors the progress of the treatment plan, when there is a relapse, a dirty drug screen comes back, what type of sanctions do you impose, and in what way do you modify the treatment plans? I'd like some discussion along that line if it's an appropriate time for us to begin talking about that, Mr. Chairman.
Sure.
I can start that off and give you from my perspective and what our court does. First of all, when they come in or when they're being considered, we're talking about assessments, my coordinator does the clinical evaluation. So, and the key here is that in a drug court, you want the high needs Okay, so you want somebody who's actually addicted to drugs. If they're not addicted to drugs, as you know, then maybe they need something different. They probably don't need drug court. So, you know, they have to screen both legally and clinically.
So they may have a substance abuse issue.
They
Maybe they occasionally get out and party with friends, and it's brought them into the legal system because they've gotten a DUI or they were arrested with paraphernalia, or so. But they may not necessarily be an addict.
No, and if they're in that situation, they should probably just go on probation, take 5 years probation, and be tested through the regular, probation, and if they'll probably be okay. If they're an addict, they're not going to make it in probation. They're going to test positive. They're going to continue to use if they're an addict. So that's the kind of person you need in drug courts, true addict. Okay, that's number one. And then when they get into the program, we're in phases. So you come in, when you come into our program, you're in phase 1, and we have treatment and counseling sessions 3 times a week. As you phase up into the later phases.
You have group treatment in that as well?
Yes, groups, yeah. And then as you phase up into the later phases, it's less. And so now, if they come in and admit that they need residential, we can go ahead and send them to residential right off the bat. If they're a heroin addict that we know is not going to make it out in the working world, trying to come to groups every other night, whatever, then we can put them in residential. A lot of the state money that we get, frankly, now from the grant process is used for the entrance fee for some of our participants to go into residential. So they go into residential. They're still in our program, but they're not with us until they come back out. Now, if they're not in residential, they come in our phase 1, and they get a first positive drug screen. We have policies and procedures that have our sanctions that are spelled out. So you get a first positive screen, 2 days in jail. Second is 7 days. Third, 14, and so forth. Fourth, I think we have 28. And we don't have a fifth. So, fourth, and after that, the DA can move to terminate the person from the program. But that's our schedule. And every drug court's going to be different as far as, how many days in jail for a positive drug screen that you can get.
When someone comes into your court and you begin with some treatment and counseling and they have drug screens, in addition to jail time, do you begin to modify your treatment plan with them as well based on those failed drug screens?
Yes, we can do, individual counseling. I'll mandate individual counseling in addition to the groups. Yes, if they keep getting positives and they're working up to their, third or fourth positive screen, we're going to have to take some either, additional individual counseling, that kind of thing, or eventually talk about residential for them.
The most important thing to understand about all of this process is continuous feedback. I think most courts have staffings in which everybody who's a member of the team sits down. We do it every week because our folks come to us in drug court every Friday at 8:30 in the morning. The feedback that you get from everybody who's a participant is that it's a constant learning process. So we start off with an assessment that continuously gets revised as we find out more about the person. We also take the attitude, and we like most folks, we have to some extent traditional first, second, third, but you got to take a look at what's going on with that person. And that's the thing about drug court. That's what makes it so interesting, is that every participant gets evaluation every time we get together. And then it's all teaching. We don't punish people. I mean, we don't like to use the word punishment. What we do is teach, and the sanctions teach. And a lot of times, these folks, my folks, have been in jail so often. Hell, 2 days in jail is a piece of cake to them. I give them community service at the dump. I do things that they don't want to do. I do things that make it difficult for them because I want to teach them. Sometimes it's go into and doing community service work at a shelter, which is where they've been probably. But everything's about teaching. Everything is about learning. Everything is about getting people to understand they got to change their life.
Mr. Chairman, question for Judge Pridgeon.
Yes.
Do you have the resources that they've been speaking about, they've been talking about?
No, sir, not in the sense that they have them. We've got to develop those resources. And it's going to take some funding. And look, part of it for us is we've got to learn too. Because you haven't had it, there may be some things out there that I'm simply not aware of that I can learn as we go through this process, that maybe I can leverage some things that are in existence that I really just quite frankly wasn't aware of that I could utilize. Whatever we do, we want to be sure we get the best bang for our buck, that we can help as many people as we can with the limited resources that we're going to have.
And of course, increased funding would help a lot in that matter too.
It always does.
Oh, it does, does.
Mr. Chairman?
Yes, sir.
I just want to make a follow-up on what Judge Pridgeon was saying, and that is that, no, there are very limited resources in many jurisdictions around the state. And, you know, when we talk about treatment, we started with this part of the conversation, that behavioral health, the Department of Behavioral Health, has got to be at the table for this, and they are, in a sense, in that they understand that there are limited resources. They know, number one, that the resources that they do have are often not set up to deal effectively with offenders, and that's the truth. And that we need to bring up the standards there as well, and they'll acknowledge that. And they're part of the drilling down into the 10 key components and helping to set standards that will make us successful. But looking at other jurisdictions and partnering with us to try to get resources in place where they're not. And like Judge Pridgeon said, there often are resources, or there's a will and there's opportunity in rural jurisdictions. I think there's a good bit that can be done there through partnership.
Every jurisdiction's got a jail, I presume, a policeman, sheriff, DAs, somebody from the PD's office, probation. If you can get the people that are already there, looking at the expenses that they're making, such as our jail is just a disaster, you know, expensive. There's where your incentive to fund these programs comes from. Is you say, look, we're spending this much on this person to lock them up. If we spent less than that, and you give me some of that money for your jail, I can get some treatment, and we can have a better outcome. That's win-win for all of us. So that's how you build your funding.
And of course, that's the direction we're looking at, is from the $18,000 that we spend if they get to the state system. Let me getting back to some of the appropriations issues, since that's ultimately what's going to be our decision. Judge Bagley, in your circuit, you talked about residential programs. Who pays for that? How do y'all fund that?
Well, as I said, we have been using some of the state money that we've been getting, state grants that we've been getting over the years, to pay for those participants who need to go into residential
That's part of your budget in the
yes,
your
sir.
application.
That's what we're using it, because we have our county funds our coordinator, and we are flush with. I mean, I'll be honest, we're flush with date money. I mean, we use our date funds. We've got a lot of money in that, and we use that to fund our operation. And our participants, I mean, we're one of the haves, Judge Pridgeon. I'll be honest with you. I mean, we live in an area most of our participants can go out and get a job, and I require them to do that. And when they come in, they're on drugs, they're a drug addict, they don't have a job, but in our area, they can find a job. Even in this bad economy, they can get something. And so I make them go out and get a job. They begin to pay, and most of our people they may be on a sliding scale, but they are paying their fees. We have certain set fees that pay most of the treatment fees, the outpatient treatment fees with our provider that does the group sessions and all of that. They have to be paid, and our people are having to pay. They're having to pay their fees every week, and they can do that because we live in an area where there are jobs, and they can go out and get jobs. I understand that might not be the case in other parts of the state, but we're lucky in that our people can not completely pay their way, but partially pay their way, then the state money that we get supplements that and helps us out.
Let me ask you this. We put some money in the budget last year specifically to provide senior judges in areas that have drug courts. And what I'm really getting from a lot of y'all is that this takes up a lot of time. This is not just sentencing somebody in where we're going to sentence 50 people in one day that have pled guilty to some felony offense, that y'all are spending a lot of time on this, which is taking you away from the other responsibilities that you have. Have y'all availed yourself of that? Is it enough to do what we need to do?
Thank you so much. I mean, that is, it
Has-
has
have you-
helped me out. Oh, absolutely. I've already got days, I'm using those 10 days. I've already got them pegged. That is such an incentive for a drug court judge. It gives you some, sense that, hey, somebody does appreciate what I'm doing. I'm doing this in addition to all my other cases. This is not something that I'm trading off. And it is really, and it's an incentive for circuits. There are 13 circuits in our state that do not have any accountability courts. And when you start talking to those judges saying, this is what you need to do, we can give you some money. They're saying, yeah, but I got, I'm not, I'm having to do that in addition to my regular caseload, not getting paid anymore. But if these senior judge days are going to help tremendously to give an incentive to those judges who might be thinking about starting an accountability court, and they'll give them a little push. And that is so much appreciated. Thank you so
Judge
much.
We keep the same caseloads as everybody else. I have 400 drug court clients and 100 mental health court, but I don't have any less caseload than any other judge on the bench. So that senior judge help is huge.
Quite frankly, if you look at the pure numbers, our usage of that senior judge money allocated for drug court is scant, quite frankly. But the timing, Charles Miller, we can speak to the fact that one that's to begin January 1. So a lot of folks have been using other resources and didn't feel like they could tap into that money just yet. So I don't think you can get an accurate picture as far as actual usage because of the way that money was appropriated.
But it's going to be spent.
It's going to be spent, but if you looked at it as a percentage, it would show very low usage right now because a lot of the judges didn't realize it was available for their usage because it wasn't supposed to be used till January 1.
I guess my question is that just like everything else we've been talking about, nothing is done in a vacuum. If we expand the accountability courts, whether we're going into new circuits or whether we are giving you additional resources where you already have the established courts so you can identify more offenders, and that's going to obviously take up more of your time. I guess my question is do you have some sense for what we need to do as far as the senior judge money that we appropriated last year to make sure that we don't put $10 million in accountability courts and then you can't utilize it because you've got the rest of your caseload that you've got to look after? I'd like a little feedback on that.
Well, what I was going to tell you is an idea that I had to use senior drug court judges. And, this may be blasphemy here in a group of judges, but really, in order to have a drug court, you got to have a judge that's willing to do it. That's number one. That's number one. And there are plenty of judges around the state that are not willing to do this for various reasons. Sometimes it's for funding, and sometimes just they don't want to do it. You could do this. If you want to expand drug courts throughout the state, you could provide senior judges to handle drug courts. You could say, well, all right, you don't want to do a drug court? We'll provide money for a senior judge to start a drug court and run it. I mean, that's an idea, to use senior judge money for drug courts.
Mr. Chairman, on our level, I've had a backup magistrate court judge that comes to all of our staffing sessions and to all of our sessions. And in the event I'm in trial or I'm tied up on other matters, he steps in and we don't miss a beat. And then when I retired recently, he moved in, of course, from my position. Now he's selected a magistrate court judge and is in the process of training him. In fact, we're going to send that judge to training this year so that he will be able to step in and we don't miss a beat. So I'm not really that concerned about senior judges on our level.
Now, I think they said it very well. There's a certain kind of judge who wants to be a drug court. I did the same thing. I took a regular case. I just have a regular caseload. And I took drug court from all the other judges. I mean, all my drug court folks came from the other 9 divisions, too. And I do you one better. I'm a senior judge now. I don't get paid for doing drug court. As I told somebody, I'm addicted to drug court. I mean, that's my addiction. I freely admit it. I don't get a nickel. I get my retirement. And I figured my retirement is paid. But it's the pay I get is doing the work. But the kind of judge who does this,
let me ask you this. You mentioned 10 days. And is that what is allocated to each drug court?
Yeah. My understanding is the first half of this year is we get 10 days.
And I guess my question, sort of a follow-up to what Judge Partain is saying, if we do an additional appropriation for senior judges, and understanding that not every Superior Court judge either has a desire to do this or wants to undertake the additional responsibility or may not have the personality for it, because I think it takes a certain degree of commitment and empathy, if you will, but not to, if a circuit is otherwise got the resources, got the caseload and all of that, should we have the flexibility that we maybe have senior judges who may want to be drug court judges instead of just filling in on your regular docket, and so that we've got the flexibility that we can do either way? Should we have either an additional appropriation for senior judges or a designated senior judge fund so that it's not just allocated to 10 days to cover for you, it's somebody who just does drug court?
Yes, I think the answer to that is yes. I would think both categories are needed, because you have some, I know, and I'm not going to name circuits, but I know of some circuits in this state that are they want the money, they want the state money for drug courts, but none of the Superior Court judges want to do it, and they're assigning this to a magistrate or a state court judge, or which is, I don't want to weigh into all that, but yes, it would be preferable from my standpoint if you wanted to assign a senior Superior Court judge to a drug court who wants to do it in that particular circuit where none of the active judges want to do it. Yes, that would be great. It would also, on the flip side, as a judge who does do drug court myself, I love to have those senior judge days to where I can have, additional, have senior judges come in and cover civil or sometimes criminal, on particular heavy days, that I have when and I still do my drug court. But yeah, I think both those categories.
Chairman Powell,
do y'all
the term
agree?
you used was flexibility, and I think what I'd like to say is that we'd certainly need it, but we'd like to have flexibility, because there's some judges who that drug court is near and dear. They don't want any senior judge coming in and touching their drug court. I mean, there's a proprietary interest among some of the judges, and what we'd like to have is, when instead of having it just say dedicated as a accountability senior judge money, is to give us senior judge money and let us allocate it where it's needed, where if someone needs 20 days and then we've got somebody else who really doesn't need any, where we can put it where it's needed and where it's desired, because like I said, in some cases...
Well, that's actually up to y'all, because all we did was allocate a certain amount of money for senior judges in circuits that have accountability courts, and if it's been allocated that you get no more than 10 days, that's not our doing.
Yeah, but we're trying to keep it fair among all.
Well, but that flexibility is up to y'all. What I'm saying is that a different category of senior judge for those circuits who qualify, but the sitting judges are not interested in doing that.
Yes, we need that flexibility too. There are circuits that want that.
And what I'm saying is, you got a pot of senior judge money, and then you've got a pot of money that says senior judges for accountability court.
Correct.
And as opposed to having those separate, just have senior judge money, because is it accountability when you have him hold criminal court while you do your drug court, or is that regular senior judge money? There's some confusion among the judges as to which pot you're supposed to be drawing from. Am I making sense in that regard? And there's some confusion there.
Well, I think that in the circuits that have accountability courts, you have the benefit of drawing on 2 pots of money, whereas the circuits that do not have can only draw on 1. I think that's the difference. I don't think you're limited that you have to pull out of one or the other. I think you can pull out of both. Getting back to the appropriation and understanding that we have heard that y'all are already appropriate or granting to some of the state courts and some of the other kinds of courts. Do we need to divide up whatever pot of money we've got and say X amount goes for felony accountability courts, Y amount goes for these other courts to encourage, because quite frankly, a lot of those folks that you see as felons who had a drinking problem that ultimately developed into to a drug problem and then puts them in the felony level, if they had that problem earlier and they were caught earlier, then they might not ever make it to your court. So we certainly ought not to neglect that, and it sounds like y'all have not. But I guess my question is, should we divide this up into 3 pots as far as the other courts, the accountability courts, and then the pilot program that we've been talking about for circuits that maybe don't have all the resources but could utilize some of the probation department services and things like that? Give us some feedback on that.
Yes, Mr. Chairman, I think that you all set the policy. The governor's office and the Criminal Reform Council has basically stated the mission is to reduce the state prison population. Well, the way you do that is through felony drug courts and felony mental health courts, okay? Plain and simple. So you decide, I think, to that end and to that goal, what amount of money you want to appropriate to those needs. And then there's also the other courts, the DUI courts that are primarily funded by the counties, the state courts, the juvenile courts, and those courts funded by the counties that also have a positive, influence on the ultimate. It may be an indirect influence on the prison population, but they may have an effect on that. And so, like you said, if you can catch these offenders at the DUI court level earlier, maybe they won't end up in felony drug court. So there might be a portion of that money that you all want to allocate toward those courts as well. So I think you make that decision as to the allocation between.
But we don't want to tie your hands. We want to make sure it gets there.
Yeah.
But we don't want to put more when maybe we get the biggest bang in felony or whatever, but we don't want to neglect the pilot project to which Judge Goss and Stan were talking about. Give us some feedback as to just raw percentages. Just tell me what you think.
What did they do last year?
Then if we screw up, it's your fault.
Yeah. Do you think we're even ready to talk about that yet?
The only thing that I could give you right now is sort of what has been done, and it appears that close to 2/3 of the funding has gone to felony drug courts treatment, and then the remaining third, I believe, has been divided up. Now I may have that a little bit off, but I think that's pretty close to how they have divided it up. Again, I mean, we provide the staff resources, we bring information to them, but they're the ones who make the decisions on how the funding is actually put out there.
And to follow up on Ms. Moore's comments, the allocations are also a function of the number of programs around the state, and approximately half of the accountability courts in Georgia are the felony adult mental health and drug courts, not just under 50%. So that's also part of what's driving this. I mean, you have different decision points here, and one of those decisions are you will impact the prison system most directly with the adult felony programs today. You will impact the prison system indirectly with the juvenile family dependency treatment court, juvenile mental health court, juvenile drug court, probably 6, 7, 8 years down the road. Either way, you will have a direct impact. It's just when that impact will be felt.
Well, and as a practical matter, even though it may be 1/3, 2/3 now, if you doubled the amount that's currently going to DUI and the juvenile, certainly it would have some more of an impact. But as a practical matter, percentage-wise, doubling $1 million to $2 million and then putting $8 million more, percentage-wise it would be less, but it would still be significant based on what they're getting now. But that gives us a little bit of feedback. What about the pilot project? What would you allocate to that? Y'all have any feel for that?
Not at this point, sir. We currently looking at where our prisons are located, assessing the needs in the community, and I'm thinking, sir, we might be able to have something in a couple, 3 weeks on that to identify. But that's a big tasking to, especially in the community, what's there and what's not, not there.
Well, give it some thought and
Yes,
give us some feedback. 3 weeks would be about the upper limit for where we've got to make decisions. All right, let me ask you this, let me ask the committee. I want to get on a little bit different topic now, just going back to the Criminal Justice Reform Council report and some of the alternatives to sentencing. Before I get there, and we can come back to accountability courts if you want to. Do we have some more questions on accountability courts, funding for accountability courts, how the funding ought to be structured? Not the agent that disperses, but how the funding ought to be structured from any of the committee members.
Mr. Chairman, I would, not a question, and I may have missed and maybe it's in here, but if it's possible to get some more documentation on how the existing grant infrastructure is set up, criteria. I know there were 10 criteria. I think that
I've given you everything.
Okay.
We've got everything.
Okay. If I can get my hands on it, that'd be
You
great.
talk to Kendra, she's got everything.
Great.
All right. Anybody else on the committee? All right. For you guys who are Superior Court judges, and we talked about alternatives to either straight probation or the prison, and I think out of the Criminal Justice Reform Council, we got probation detention centers and day reporting centers. And there is no additional money that I see in the budget for any of these alternatives. And I guess my question is that, do y'all feel strongly enough about the need in the accountability courts that you think we get the biggest bang there, or do we need to try to do some of these other things that don't necessarily deal with mental health or drug and alcohol dependency issues?
I feel strongly that reentry is a huge, I don't know if that's what you're talking about, but reentry from the prison to the streets is a huge problem. $25 and a bus ticket home is a huge problem. And we've got to have something in between that. A lot of these people max out, and they're just no supervision at all.
I think that's addressed in the Criminal Justice Reform report. You have something to add to that, Ryan? That would be great.
One thing to add to that is we believe we put $1.4 million in the budget for expansion of parole officers. I'm not sure that it hits probation. You can correct me, Stan.
No, haven't yet.
That would go for the purpose of dealing with these folks who leave, I guess, without any supervision on the back end.
Yeah.
And that's what that funding was for. I know that there's some trip up there with some of the mandatory minimum. There's some of those folks we can't cover, but there's a vast majority of folks we can. So they're not leaving and just getting bus ticket and hotel room.
Yeah, Judge Downs, I think my question was, one of the things we heard in the Criminal Justice Reform Council was that right now judges have two choices: prison, straight probation. And that there are some people who need more supervision, they need more hand-holding, but they can be successful with that. But under the current structure, if you are a sitting judge and you have somebody that's in that category and you realize that those resources are not available to protect the community, you're going to send somebody to prison, which is not the best thing for them, but it's under the circumstances the best thing for the community, but it's not the best.
Effective.
Well, and it's not the best utilization of our resources. And I guess my question is, one of the things that came out of the Reform Council's recommendations were that we need daily reporting centers. We need probation detention centers so that if you get somebody who screws up, you've got a choice other than sending them back to the system. You can send them to a detention facility for 30 days or whatever it is to try to get their attention. And we currently don't have that in place. We need that. My question is that do we need it bad enough that we reallocate some of this $10 million, or do we need the $10 million to go to the accountability courts most of all, and we can wait for another day for these alternatives? That's my question.
Well, I think it ought to all go to accountability courts.
Okay.
Well,
You're a senior judge. You don't do that stuff anymore.
yeah, I do. I just stopped doing it a year ago, so. But for 26 years, I will tell you this, I love drug courts, that's pretty obvious. But drug courts are dropping the bucket of the people that really need help. Oh, the rest of the people that don't get drug courts, they need something. And they need something it's a mistake to put them in prison. It's a mistake to put them on straight probation. And that's the great majority of people. So would I take money away from, it would be like cutting flesh off my body.
It's a hard decision.
Yeah.
But
it's a
that's what
very
I'm
hard
asking
decision.
y'all.
Yes, the answer is, in my opinion, personally, just for me, and they're going to get angry with me, you need something for the people who are on the fence one way or the other. And putting them in prison is an enormous waste of resources. So the answer to your question is, if it came down to that, I hope it doesn't. Surely there's some other places where you could take, I won't mention fishing or things like that, because that's not my business.
Well, it's not in our public safety budget.
I know. But that's, you wanted opinions.
And that's what I'm asking for.
Okay.
Yes, sir.
I don't know if you are familiar with this, but there is a concept, and I'm not aware of this in Georgia, but reentry courts using the drug court model, and back end when they come out of prison. And there are reentry courts in the country, so that's another something to consider. Developing reentry courts in Georgia. I'm not aware of any in Georgia. Do we have any?
Yeah, we're doing it.
We're starting one in
Okay.
Fulton.
All right, well, one or two that are starting. But that's a concept that kind of fits in what you're saying, really, and it's run by a judge, and that's the most effective way to deal with some of these folks is to have somebody who's got a big hammer.
I think ultimately we're talking about a continuum of care that brings together the community-based treatment services that are already in place, the accountability courts, the probation and parole and supervision, and figuring out a way where we can have all these people working together for the common interest of the offender, whether it's on the front end before they get into the prison system, or whether it's on the rear end as they're coming out of into the reentry mode, wherever that is, and there's got to be that continuum of care. I talked about the aftercare for the accountability court graduates, and I agree I don't like the term graduate either, but I talked about that being so important to have that piece ongoing within the treatment community, but it's just as important for those that are coming out of prison and trying to reenter. Maybe more important for those that are coming out of prison and trying to reenter.
Mr. Chairman, the gains model that's attached to the handout, number 4, that's reentry. I mean, 3 is the treatment court, 5 is parole probation-driven model, 4 is in between. And Judge Partain is correct. There are some reentry programs nationally. We've started a track with our mental health court that we're doing that, and it felt like we've had some pretty good success. But it's a facet. But to answer your direct question, my personal opinion is this $10 million needs to be focused on treatment and accountability courts and any program that's delivered through probation to the rural counties, because $10 million is a lot of money, and I am extremely appreciative to the governor's putting that in the budget. But at the same time, if we start then peeling off and putting this for a detention center or that, we dial $10 million is a lot of money, but then again, it's not a lot of money.
Mm-hmm.
I'd rather see the state focus on this and try to do this a lot better than to dilute it down and maybe not get the impact that the administration is hoping to get. That's my personal belief.
Well, that's what I'm asking for. You agree? Okay, we got a lot of nodding
unanimous.
heads. No, it's not. It was almost unanimous.
Sorry. I got those looks. That's my opinion.
We're all friends here.
Yeah.
Ryan, Chris says he needs you back at the office. And I told him I would excuse you. You're excused.
Thank you for having me.
Thank you for coming. All right. Any other questions from the committee? Any other comments from our panelists? I do appreciate all of y'all coming. I know that y'all, based on what y'all have said today, y'all got other things to be doing, but this is important enough that that I appreciate your input. And before we go, I'm going to let any of y'all make any kind of closing remarks that you want to make, but I just want you to know that we appreciate, y'all have educated us a lot. Don't y'all agree?
Absolutely.
Yeah.
Representative Powell, I'll make one comment. This is a different format, but I compliment you. It was extremely effective as far as getting a lot of information out. I appreciate you doing this. Sure do.
I'd like to say that I'm not sure it's been said formally and properly, but on behalf of the drug court and accountability court judges, we thank you. We thank the governor for this opportunity. It's amazing that we're here doing this, talking about spending $10 million for accountability courts. And we appreciate what the legislature has done in the past for us, and we appreciate that what you're trying to do this year and what the governor's done as well. So on behalf of the judges, thank you very much.
Okay. And if y'all will, give us some information and some feedback about the pilot type thing. And my guess is we got a ways to go, but I think this gets us a lot further than where we were. But I think we're looking at trying to put some senior judge money for circuits that don't have accountability courts that qualify, and so that a senior judge could be the accountability court judge. That's what I'm hearing. That's a consensus. I'm hearing a consensus of 3 pots of money, one for the DUI, juvenile, and that. The biggest pot of money being for the felony accountability courts, and then a pot of money for the pilot project. And if y'all disagree, you can let me know now, or you can let me know later, but that's sort of the direction we are going to head. So, and thank you very much, because I don't think we would have done it right if y'all hadn't have come today. Marla.
I'll say one more thing, sort of related, but not part of this, is a request that we have in for a case management system.
Oh, I understand that's integral. You can't see how accountable the accountability courts are unless you have that data information.
Right.
I understand that.
This is part of our Judicial Council AOC responsibility statutorily.
We'll be we'll be talking about that when we get to your budget, but it's there, and I know why it's there, and it's an integral part of this, okay? Anything else? Thank y'all.
Thank you, sir.
Thank you very much.
Mr. Chairman, good job.